Good morning to those who are joining. We're going to give people a few minutes to populate our Zoom room before we get started. So we'll give it a minute or two as the system works itself out. Just going to give it one more minute for attendees to fill in the room. Okay, why don't we get started? Good morning, good afternoon, good evening from wherever you may be joining. My name is Michael Berger, and I am the Executive Director at the Sabin Center for Climate Change Law. And it's my honor to be the first speaker on today's panel. We're joined by a distinguished group of speakers from here in New York City, across Northern Europe and South Africa. One of our planned participants, Ramin, Pejan, is ill and not able to join us today, but I think we have enough speakers to fill the time and enough material to give adequate coverage to the topics in any event. So my role here is really just to kick things off with some introductory comments and set the stage on global climate litigation, and then I will hand it off to Skelton, who will take it from there. Give me a moment to share my screen, and then we will get going. Here we are. Great. So again, my role here is to sort of set the stage for the question of whether, how, and why the CRC's new general comment on children and climate change may be a tool for climate litigation. The topic that will be addressed from a number of different angles over the course of today's session. I like to start off by just taking a quick step back to recognize that we are not on target or we're not on a trajectory globally that is consistent with the Paris Agreement's global warming temperature targets. The rationale for this, or one explanation for this, is that the policies that have been adopted by national governments around the world are insufficient. That is, we do not yet have global national policies at the global level that put us on the appropriate trajectory for global warming. We also have, and that, I should say, can be thought of as something of a policy gap between where we are and where we need to be. We also suffer from a production gap, which is to say the rapid ramp down of the production and use of fossil fuels that is necessary in order to meet the Paris global warming targets is in juxtaposition with the reality of the planned production and use of fossil fuels that we see coming into the market. So this policy gap and this production gap, among various other forces, lead to an overall failure that has caused a range of different actors to go to court seeking climate justice, climate equity, and government and corporate action that would be consistent with avoiding the worst consequences of climate change. At the Sabin Center, we maintain two databases of climate cases from around the world, one for the United States cases and one for global cases outside the United States. This is freely available at climatecasechart.com and forms the basis for a great deal of the analysis of climate litigation that happens at universities, in practitioners' offices, in government and intergovernmental offices around the world. Based on the data that we compile at the climate change litigation databases, we at the Sabin Center, and most recently my colleague Maria Antonia Tigre, who you will hear from a little bit later, have worked with UNEP to produce a global survey of climate change litigation. Our most recent third report was just launched in the last few months. And the purpose of this report is to provide sort of a global overview of climate litigation, the status of different cases, and current and future trends that we see in the courts. The report is divided into several sections, and it's also freely available online for your reference. One of the key findings in terms of the numbers of cases, climate litigation has more than doubled since our first report was issued in 2017. The numbers that are here are a little bit dated. They're a few months old, but even as of a few months ago, there were nearly 2,200 cases. Now I believe that's over 2,300 or more in 65 different jurisdictions. And that's compared to 880 cases that we had in 24 different jurisdictions 6 years ago. So there's a growth in the number of cases in an increasing number of jurisdictions, and we're also seeing an increasing number of theories or causes of action that are taking place. So this slide represents the increasing numbers of jurisdictions. We do maintain the US as a separate database because, as you can see, it's really an order of magnitude more cases in the United States as compared to the next largest jurisdiction, which is Australia. And so the US cases make up somewhere between 66 and 75% of the cases that we see at any given point in time. Right now, cases outside the United States are at around 30%, and cases inside at around 70%. In the last IPCC report, it was recognized that climate change plays an important role in influencing the outcome and ambition of climate governance. This was the first time that the IPCC report made such a determination, and this was made with moderate confidence. So we're seeing more cases in more places under more causes of action, and an increasing recognition of the importance that these cases play in steering and influencing what governments and companies are actually doing. The report that we issued with UNEP identifies and assesses and sort of talks about cases in half a dozen different key trends or trend areas. I think that in thinking about the CRC report, really the first two or maybe three of these are the most likely trend areas or categories of cases where we're going to see the CRC comment have a significant influence, and these would be cases where climate rights are at issue, where entities are seeking to enforce through domestic courts international climate commitments, such as the Paris Agreement, and also in cases where keeping fossil fuels and carbon sinks in the ground can be connected back to the global phenomenon of climate change. The report concludes by identifying some future trends, and here I would just note that among those future trends are cases brought by vulnerable groups, and I believe that children may well be one of the groups that we have seen a good amount of cases from already, and we may well see more in light of the CRC comment and its outcome. So I'm going to stop sharing my screen, and I will say thank you for the opportunity to give these opening remarks. I apologize that I will not be able to stay for the remainder of the panel, but you have a great group ahead. And so I'll turn it over to Anne Skelton, the chair of the Committee on the Rights of the Child at the Office of the High Commissioner on Human Rights. Anne?
Thank you very much, Michael, for setting the scene in that way. I think it's very useful, and please feel free to leave if you have to go on. But we will continue with our conversation here. So it's a great pleasure for me to talk to all of you who have joined this meeting about the general comment number 26 on children's rights in the environment, with a special focus on climate change. The document was actually adopted in May this year and then officially launched just recently in September. It's been a very exciting process. It's been informed by many inputs from a lot of stakeholders, from states, from civil society, and from children themselves. And so we're really happy with the outcome. And now the next step is implementation. So we're very keen to think about how can this general comment be made meaningful and real. So one of the first questions that people tend to ask about general comments, of course, well, certainly all my students ask, but they're not binding, are they? So, what do we do with them? So it really is an important strategy to get general comments cited in law reports, to get them mentioned in judgments. And in order to do that, we have to get lawyers including them in their arguments. So I think this is a very important conversation that we're having, because the idea is that a general comment can move from being non-binding to being binding, or aspects of it can, if it gets used by the courts, because then it becomes embedded into the domestic law. We've seen in various jurisdictions that courts can be quite keen to use general comments. What a general comment is essentially is an authoritative interpretation of the convention by the committee. And this is often used then by courts in filling out their own interpretation of possibly domestic laws, measuring against a constitution, and of course measuring against the Convention on the Rights of the Child. So but of course, unfortunately, those litigating in the United States of America is the only state that wouldn't be able to directly draw on the convention, although I do think it could be used possibly, because we've seen that it has been used in the death penalty cases against in relation to children, where the Convention on the Rights of the Child was used as a kind of indicator of evolving standards of decency. So I think it's not completely lost that it could be used in the United States, but there are obviously other jurisdictions where its applicability would be far more direct. And I think here of my own country, South Africa, where the courts are quite keen on using general comments, but I won't say any more about that, because I know Karabo Ozah from South Africa will be speaking and she'll tell us more about that. So really, I think what is in the general comment that might be very useful to use in litigation, of course, it sets out all the rights of children that are affected. And so that helps us, again, to kind of fill in any gaps that there might be in domestic law or domestic constitutions. We can say, well, even if it isn't spelled out, that the right to play or the right to leisure or the right of indigenous groups are affected, we can use the general comment to be able to fill those gaps and to help the court see the applicability of the convention in those circumstances. Beyond the statement of the rights that are in the convention, this document is the first document internationally that claims that children have a right to a clean, healthy, and sustainable environment. Of course, that isn't entirely new, because it had already been stated by the Human Rights Commission, and also the Human Rights Council, and also in respect of the General Assembly, who'd issued declarations in this regard. But it's significant, I think, that it's in a general comment and is specific to children, and it's broken down in ways that show its applicability to children. I also think it's quite important that we shouldn't always think of children as being a vulnerable group, but also a group with agency. And I think in the balancing of rights in this document, the fact that children are people with agency who want to be involved and who may engage in protest action and so on, their rights are also protected. And should they find themselves in trouble, these provisions could be very useful for them as well in that regard. And also meaning that they should be able to engage and participate in decisions. Beyond that, I think there are some very detailed provisions on states' obligations to protect respect, protect, and fulfill. There's talk about their non-regression of rights. So this is very relevant, I think. Moving on from there, there is a section on child rights impact assessments, which again, I think we can build into litigation that might be targeted at showing that projects that affect the environment have gone ahead without doing proper child rights impact assessments. So that is usefully set out in some detail. Children's rights in the business sector also is engaged with. So it is the responsibilities of business role players and states' obligations to regulate are spelled out here too. Then there's a very detailed section on access to justice and remedies, and that might be used to overcome any difficulties with standing that we might see that children might have as litigators. International cooperation is another area that is flagged and could be important depending on the remedy that is being sought. This could be useful in certain types of litigation. Part of the general comment deals specifically with climate change, and there is guidance on adaptation, mitigation, adaptation, loss and damage, which could be useful in some contexts of litigation, again, business and climate change, and climate finance. So I actually think that of the categories of litigation that were listed by Michael, he said that he thought just the first few would be engaged, but I saw there corporate liability, climate disclosure, and greenwashing. All of these are actually mentioned in the general comment. So in my view, I think the general comment might be useful for all of the categories of litigation that we will see. And so I think the possibilities are there, and we just need to get lawyers reading the general comment, knowing it, and thinking of it as a very useful tool to augment the legal arguments that they will already be making. Finally, where should this be done and how? I'm only going to address at the international level, but I can tell you that the committee is already thinking about how can we get this general comment in front of the International Court of Justice, because states can put documents before them, so can recognized observers. So we're working on trying to get it in front of them, and also the Inter-American Court of Human Rights. We're interested in getting it in front of them as well. So that's what we are doing, but I'm looking forward to hearing about what everyone else is thinking of doing. And so I'm going to hand over to the next speaker, who I think is Maria. Is that right?
Yes, thank you so much. And this is a perfect overview of some of the main aspects of this very long general comment, which is certainly going to be extremely useful moving forward. So I wanted to highlight a few points today related to the indirect consequences of climate litigation, and then the recognition of the right to a healthy environment, which Anne already touched upon a little bit, but I'll expand a little bit more on that. So I think, it's interesting to see sort of the development of this, and the committee started discussing child rights and environmental issues in 2016. But it was in 2021 that it really showed its intention to focus on the general comment on children's rights and the environment, with this particular focus on climate change. So in the general comment itself really shows, acknowledges that, like Anne mentioned, this aspect about children as being agents of change, right? It really acknowledges that it was really their effort that draw the attention to the climate crisis that we're facing, and they're really the driving force behind this initiative. So, Mike mentioned our UNEP report, and we have a specific session within the report that highlights the children and youth cases. And as of December 2022, when it was last updated, we had over 30 cases that had been brought on behalf of children and youth based on human rights, focusing on their vulnerability to climate harm and the principle of intergenerational equity. And I'm sure that this number is a lot higher today. We haven't updated the count yet, but these cases really argue that due to their youth, they will bear the brunt of climate change impacts for extended periods. And obviously, all of these are very relevant in pushing the boundaries and so forth. But there was one case in particular that really played a very essential role in this journey to get to this general comment, which was the complaint that was brought by Chiara Sacchi and 15 other child complainants against 5 states in 2019 before the Committee on the Rights of the Child. And this complaint specifically centered on the failure to prevent climate-related human rights violations, neglecting international collaboration on climate issues, and disregarding the precautionary principle, and failure to ensure intergenerational equity. And there's a big perception that this case was ultimately very unsuccessful because it was deemed inadmissible due to a failure to exhaust domestic remedies. But I always like to really highlight this case as an example of these indirect effects of climate change litigation, right? Because the committee really took the opportunity there to clarify certain aspects of the law as it applied, as it made this connection between climate law and children's rights. So it did say that it imposes extraterritorial obligations to address climate change and define criteria for jurisdiction concerning environmental harm, and recognized that the complainants had actually experienced substantial harm, justifying their victim status in that case. Emphasize also the foreseeable nature of harm resulting from carbon emissions that's supported by scientific evidence. And it really amplified the urgency of addressing climate concerns, and then galvanized this interest in addressing these issues by the committee. So I think it's really important to keep this in mind, because I really see climate litigation, sort of the movement as a whole, as pushing the boundaries further and further. Obviously, it's not going to be at the pace that we need it to be due to the climate crisis that we're facing, but all of these things add up to really create this whole global movement and really pushing the boundaries further and further. So looking specifically at the right to a healthy environment, right, and how that was established in the general comment, obviously it's very undeniable that that climate change disproportionately affects children's rights, including the right to life, to survival, development, the right to the highest attainable standard of health. But I think one of the very significant contributions that the general comment does is really this explicit recognition of the autonomous right to a clean, healthy, and sustainable environment as protected by the CRC, right? And this, as Anne mentioned, aligns with this international recognition by the Human Rights Committee and the General Assembly, and provides practical guidance on how this should be implemented with respect to children. So they specifically note that a clean, healthy, and sustainable environment is a human right and necessary for the full enjoyment of a broad range of children's rights. And they include substantive and procedural elements of this right. And I think the panelists later on will talk more about the procedural elements. So I'll focus a little bit more on the substantive aspects in my talk. So specifically, they mentioned that the committee mentions that states have a duty to respect, protect, and fulfill this right, and that imposes immediate and progressive obligations. And this would take sort of a longer talk to discuss the intricacies of all of that. But they specifically note clean air, a safe and stable climate, healthy ecosystems and biodiversity, safe and sufficient water, healthy and sustainable food, and non-toxic environments. And this really aligns with what the rapporteurs on human rights and healthy environments, so John Knox and David Boyd now, and have sort of delineated as part of what the right to a healthy environment means, under international law and then domestic law as it is applied. And then they specifically mention some certain actions, right, that the states should immediately take and then progressively take as well. So some of these include improve air quality, reducing outdoor and household air pollution, prevent child mortality, conserve and protect and restore biodiversity. And they also specifically mention certain actions in terms of climate mitigation and adaptation as well. So they mention equitably phasing out the use of coal, oil, and natural gas, ensuring a fair and just transition of energy sources, and invest in renewable energy, energy storage, and energy efficiency to address the climate crisis. So really some very specific obligations that states will have in terms of mitigating climate change. And they have, a long section on mitigation, one on adaptation, one on loss and damage. And I think it might be one of the most progressive in general statements that we have seen from the United Nations sort of at international level on these specific obligations and how that relates to states. So I think it's really useful as we, and mentioned, it's not a binding agreement, but it does have this authoritative status, which can be improved over time. And it's really useful to have those specific obligations as it applies to children in terms of what the obligation to mitigate and to adapt and then address loss and damage as well as part of the obligations of states. Another point that I wanted to make is that the general comment really highlights the link between the convention and environmental harms impact on children across the rights spectrum. So obviously, like looking at this intersection between other norms as well, and always looking at that harmonization of international law at the same time. And then specifically also related to obligations towards environmental rights defenders. We've been seeing, I think, especially in Europe, but this really scaling up of cases that are being brought against climate defenders and climate activists around the world. So I think that's an important topic that we're gonna be discussing moving forward. And then children participation in environmental decision-making processes at all levels as well, which I think some of the other panelists will touch upon. So really, sort of in conclusion, I think it's really a very important norm that we have now that can really open up a new chapter for climate litigation, right? Because now plaintiffs have this guidance on how the CRC should apply and then can push for these obligations as it relates to international law and then applying that within the domestic law, the domestic legal systems as well. And, we're gonna ask some questions at the end, thinking a little bit about how that applies to the ICJ advisory opinion that's coming, and then the Inter-American Court as well. And I think it's really important that we discuss that as well. So I want to leave that out for our Q&A. So that's it for me, and I'll head over to Aoife. Thank you.
Thanks so much, Maria Antonia. I'm Aoife, and I am so delighted to be in such distinguished company today. Thank you so much for having me. I first want to acknowledge, the breaches of human rights and children's rights that are happening in Israel, Palestine. Obviously, that's not the topic that we have here today, but my thoughts are really with colleagues and friends over there at this time. So what I want to talk about today is basically how there is so much opportunity for using children's rights in climate litigation. And I will be brief today because we've so much interesting and exciting material to get through. But if you would like to see what I'm talking about in more detail, I have a recent article here that I published in the Netherlands Quarterly of Human Rights just last week, where I go through some of the arguments that I make about how defining children's rights as part of the rights of future generations and as part of intergenerational justice more explicitly in climate cases is something that I think should be happening. And this kind of comes from the fact that, when you look at all these climate cases, it occurred to me, and it occurs to Elizabeth Donger as well in her really excellent article last year about children and youth in strategic climate litigation, that when she looked at the 33 children and youth focused climate applications, which were rights focused before 21, 90% of them referred to intergenerational equity and the rights of future generations, which is all great, really positive. It's a principle and a concept that's working in a lot of these cases. But it's so striking that less than 10% of these cases were referring to the best interests principle. There's really a lack of attention explicitly to children's own rights, the rights of children that are here now, experiencing things now, and especially to the Convention on the Rights of the Child. So this general comment, is coming out in this context, and I think there's just so much exciting potential to bridge that gap between the concepts that are being used at present and the CRC, and making it more of a priority for, and as Professor Skelton said earlier, lawyers can use the general comment in their arguments. The general comment is bringing to life, giving more elaboration to the rights and principles in the UN Convention on the Rights of the Child. And I emphasize the best interest principle, and I know it's a little bit, you don't want to do that unduly, because the best interest principle does not define the UN Convention on the Rights of the Child. And it can be quite a paternalistic principle of adults telling children what to do and telling adults what's best. I have a big body of writing actually around just that topic. But when it comes to the environment, I really love the best interest principle for a number of reasons. It's really prominent in national legal systems. My colleague Laura Lundy and others, in examining the best interest, or examining the implementation of the UN Convention on the Rights of the Child all around the world, back in 2012 and a little bit since that as well, just noticed that it is very much incorporated in most domestic law systems. It's widespread. It's the most cited article of the CRC by national courts. And the thing about it is that it draws attention to children's interests rather than the interests of others, interests such as perhaps unfettered economic growth. So it's so useful and important for that reason. And there are so many obligations on states iterated in other general comments in other places by the committee and by other authorities to ensure that the best interests of children are considered adequately in all matters concerning them of public policy, law, and so on, but also environmental matters. And part of this, again, as Professor Skelton noted, are children's rights impact assessments that states are obliged to carry out on matters affecting children, which environmental policy inevitably does. And part of that is collecting data, understanding the effects of various policies and laws on children. And especially since we have the Paris Agreement and states have obligations there too to develop plans as to how they're going to mitigate their emissions and other things like that. But UNICEF's research back in 2020 found that most states don't give explicit primary consideration to children's rights. And in fact, in only 34% of climate plans could it be said that they were actually child sensitive. In only 12% of climate plans were children consulted. And of course, the best interest principle, you can't understand what children's best interests are if you're not consulting children themselves. So all of this strikes me when, the topic under consideration here is litigation, as so many avenues for holding states to account. Every state, except the US, has ratified the UN Convention on the Rights of the Child, and so they have signed up to do this, to ensure that children's best interests are considered in laws, policies, plans, and so on. And part of that is collecting data, part of that is children's rights impact assessments, and we can see that states are not doing this. This gives opportunities to bring children's rights into litigation. Now, of course, there'll be all kinds of reasons why it's complex to do that, because of dualist legal systems where courts are reluctant to consider unincorporated human rights instruments and things like that. Lawyers who are not children's rights lawyers, who may not be so familiar with these kinds of principles and arguments. But this general comment, I think, gives us a good opportunity to get the word out there, to make sure that the best interest principle and other children's rights principles are well known to those litigating cases. And we can see how helpful general comment number 26 is when we, have the committee reiterating that the best interest of the child shall be a primary consideration. States have to conduct assessments of the circumstances of children when it comes to environmental plans, policies, laws, and so on. There has to be child rights impact assessments. And of course, it's not always going to be, cut and dried as to what the best interests of children are, because if you are moving things around, like cutting certain bits of environmental sectors, there may be knock-on effects of children's parents' earnings and that kind of thing. So there may be conflicts there that have to be resolved, and the general comment says that this has to be done on a case-by-case basis. To conclude, I think we need to insist that there is more explicit use of and reference to the UN Convention on the Rights of the Child in climate cases. I think that this general comment gives us a lot of opportunity to do this. It elaborates on the principles of the CRC in relation to children and the environment. I'm very fortunate, actually. I have a 5-year project funded by the European Research Council, whereby I've built a team now, and we're going to take all of these climate cases involving children as litigants or children's rights arguments and kind of analyze them all from a children's rights perspective. We're going to talk to as many of those litigants as we can and find out about their experiences as they, are involved in litigation. And we're also going to talk to children in various parts of the world about their experiences as children, as climate or environmental advocates, and express, what this means for the UN Convention on the Rights of the Child, that children are now such leaders in this environmental space. And the general comment number 26 will really help with that work as well, to get children thinking about their rights now that we have elaboration on those rights, and it's a very exciting time. So thank you very much for listening, and I'll be delighted to engage in the discussion later.
Thank you so much, Aoife. I believe I'm next, so I'll get my presentation up. So I hope everyone can hear me. Hi, everyone. I am Freya Doughty Wagner from Washington University in St. Louis, and my research focuses on intergenerational equity and how children are impacted by climate change, and how international law can protect this. So as you can imagine, General Comment 26 coming out was pretty fantastic for me. Also, just reflecting on what Aoife just said, I find it so interesting the way that General Comment 26 and the way children's law and international law is now reframing children fascinating. Because if you look back, to the 1800s, the way children were chatteled and now how they are agents of change is just fantastic. So today I will be talking about specifically access to information in the general comment, and the right to participation and how it enshrines these two and really fleshes out these rights and these beliefs, and the way children can become active and successful climate litigants. So to start with, there we go. I will be talking about information, but I will give a brief overview. So virtually every human right afforded to children is threatened by the climate crisis, from the rights to life and education to culture and development. Its impacts are inescapable. One of the crucial tenets of the United Nations Convention on the Rights of the Child, the UNCRC, is that all actions concerning children must make the best interests of the child a primary consideration. Yet neither the UNCRC nor its general comments addressed how to uphold that best interest principle without incorporating protection from the climate crisis until now. So in June of 2021, the UNCRC committee pledged to draft a general comment concerning children's rights and the environment, specifically focusing upon climate change. And the committee, together with the Children's Environmental Rights Initiative, consulted thousands of children over 100 countries to construct General Comment 26. Children's voices were centered as part of this discussion. The drafters crafted a child-friendly general comment, worked with a child-led advisory team of environmental activists, and had youth activists, including those who were part of the CRC petition on the General Comment Advisory Board. Then in October of 2021, the committee invited comments on its initial concept note, which stated the main objective of the general comment was to provide authoritative guidance to state parties to undertake all appropriate legislative, administrative, and other measures of a child rights approach to environmental issues with a special focus on climate change. It provided 5 aims, number 4 of which I will be discussing just after I mention them. So number 1 was to clarify the extent of states' obligations relating to climate change and children's rights, including with regard to mitigation and adaptation. Number 2 was to emphasize the urgent need to address the adverse effects of environmental harm and climate change on children. Number 3 was to clarify the relationship between children's rights and the protection of ecosystems, biodiversity, and management of and access to natural resources. Number 4 was to clarify how children should be able to exercise their rights to information, participation, and access to justice to protect against environmental harm. Number 5 was to shed light on societal, legal, and other implications of concepts such as international cooperation, extraterritorial obligations, future generations, and intergenerational equity, with a view to improve the legislative, administrative, and other measures that states, as well as other stakeholders undertake to uphold the rights of the child in the context of the environment and climate change. The 4th aim, clarifying how children should be able to exercise their rights to information and participation, is particularly relevant because without which child-led litigation would not be possible. So regarding information, section B of the general comment discusses specific rights under the convention as they relate to the environment. Several rights are important here. Unsurprisingly, the right to be heard, Article 12. In the general comment, it says that for free, active, meaningful, and effective participation, children should be provided with environmental and human rights education, age-appropriate and accessible information, adequate time and resources, and a supportive and enabling environment. By including a climate-informed education as part of children's curricula, which is also included later on under the right to education, they are immediately placed in a better position to A, understand the wider impacts of climate change, B, how this affects their fundamental human rights, and C, that they are able to turn to a resource or remedies regarding these breaches like litigation. The right to be heard continues, requiring children receive information about the outcomes of environmental related consultations and feedback on how their views were taken into account, and have access to child-sensitive complaint procedures and remedies when their right to be heard in the environmental context is disregarded. This is another vital inclusion for child climate litigants because participation simply is not effective and their views not respected if feedback is not both given and child-sensitive. The general comments drafting team are a remarkable example of including children's voices and disseminating child-friendly and child-appropriate documents and responses. It then moves on to access to information, unsurprisingly, with Articles 13 and 17. They are highlighted in the general comments stating that this is essential for enabling children and their parents or caregivers to comprehend the potential effect of environmental harm on children's rights. The general comment calls this a crucial prerequisite for children if they are able to obtain an effective remedy regarding environmental matters. Access to information also includes an obligation for states to make environmental information available, with dissemination methods to be appropriate to children's ages and capacities and aimed at overcoming any obstacles such as illiteracy, disability, language barriers, distance, and limited access to information and communications technology. This would be imperative for youth climate litigants, as access to information that is understandable at all, or at least to many stages and abilities, ensures a wider and a more inclusive cross-section of children impacted by anthropogenic climate change, ensuring this greater cross-section has the chance to be active participants in climate litigation. The last point I will make regarding information is under the access to justice and remedies section. As being informed about the detrimental impacts of climate change, of course, is the first step to becoming an informed child litigant, but this alone is not enough. Paragraph 90 of the general comment request states make applicable international and regional human rights mechanisms available, including through the ratification of the optional protocol and a communications procedure. It continues, information about such mechanisms and how to use them should be made widely known to children, parents, caregivers, and professionals working with and for children. Informing children and their caregivers of the potential remedies at their disposal, whilst probably unlikely to be performed by many state organizations, is still a step forward. Regarding participation, unsurprisingly, again, the right to be heard is the most comprehensive section discussing participation. Best interest of the child is also mentioned, as it says it is within a child's best interest to provide effective and meaningful participation where an environmental decision may have a significant impact on children, but it does not really extend further than this. So under the right to be heard, or paragraph 26 of the general comment is where this mostly starts. It crucially states that children's voices are a powerful global force for environmental protection, and their views add relevant perspectives and experience with respect to decision-making on environmental matters at all levels. Children's views should be proactively sought and given due weight in the design and implementation of measures aimed at addressing the significant and long-term environmental challenges that are fundamentally shaping their lives. It continues encouraging children to use creative means of expression, such as art and music, and requesting children requiring additional support, such as children with disabilities or living in vulnerable areas, be provided this, so they too may exercise their right to be heard. The right to be heard also includes requesting states, intergovernmental organizations, and international NGOs facilitate the involvement of children's associations and child-led organizations or groups in environmental decision-making processes. Further, under the general measures of implementation, the general comment mentions the obligation of states to combat negative societal attitudes to the children's right to be heard and to facilitate their decision-making. Pejan, an organization heavily involved in the creation of the general comment, have turned their focus to this, saying, children have the right to be heard, but do adults listen? A survey of 2,500 children in 53 countries found children repeatedly reported that adults are the major obstacle in the realization of their civil rights, with one particular child, a 17-year-old girl from India, saying, we understand what is right and what is wrong. My message to adults is to please allow us to participate. Shifting negative societal attitudes towards children's voices is imperative if we want a greater number of children to take part in climate litigation. Children are eager to have their voices heard, and hopefully the general comment will aid in cementing this right and uplifting children to truly feel like they are agents of change. Giving children and youth access to child-friendly information concerning climate change and access to remedies, and instilling their fundamental right to be heard are crucial tools if we are to increase accessibility to the incredible tool of climate litigation. General Comment 26 explicitly puts forward the necessary steps for states and connected organizations to include children's voices. Hopefully, many will follow the work of the Comments Drafting Committee and make potential climate remedies child accessible and genuinely listen to their eco-anxiety concerns. Thank you so much. I look forward to questions afterwards, and I believe it is Asteropi next.
I think it's first Karabo. I think so, but please correct me if I'm mistaken. I'm happy to go now, Aoife.
No, I think Karabo is the next speaker on the list.
Yes, thank you so much. Good afternoon, everyone. Thank you so much for this opportunity to reflect on General Comment 26. I think, as a starting point, certainly some of us who litigate and work on children's rights have been waiting with bated breath for it, because it's already been said there is quite a lot in there that is useful for purposes of litigation. And I will share some thoughts on what's happening in South Africa. As I mentioned earlier, I'm in South Africa. But I think as a start, if you look at the general comment and the purpose of it already is something as captured, the objectives of it is captured in its text, is already something that helps us a lot. And I think everybody has been reflecting on the fact that for the first time, we have a clear guidance on how the rights of children are clearly interrelated insofar as the environment is concerned and climate justice, which is something that we already were seeing a little bit of struggles as we start trying to unpack how we're going to advance the rights of children in relation to the environment and climate justice in our respective countries. So the detail in this general comment is very welcome. Also, the clarity on the state's obligations. I think it's already been touched on how it is clear that states have obligations in relation to what they must do, but and actions that affect them and what they plan, but also how they should hold business accountable. And we know that is also a very important aspect of this area of law, because our states give certain businesses licenses to do mining. They give them licenses to do all sorts of things that we know affect the environment and then have an impact on children. So having this, again, will help us to strengthen arguments where one has to hold government accountable and make sure that they're holding businesses accountable. And this we know in the coming years and even already is something that needs urgent attention. So in South Africa, we have quite a lot of provisions and different legislation dealing with different aspects of environmental rights. In the most, the laws are compliant with international provisions insofar as what should be done, and they flow from our constitution, where we have a section 24 that clearly sets out the right in relation to environment and the fact that the state has an obligation to ensure that we have a clean and healthy environment. So that is already there. And then we have, as I said, the domestic laws. But what the domestic laws provide is a lot of provisions, different aspects, whether it's quality of the air, whether it's mining. They have a lot of different provisions in relation to what should the state do when they're granting people licenses, or where they plan, for instance, to now come up with a new coal-powered electricity or a power plant. And I will come back to these aspects because I'm just going to be reflecting a bit on two cases that are pending in South Africa on these issues, and how issues pertaining to children are coming to the fore, and how they're now having the general comment would strengthen that. So as a start, I mean, in relation to this issue of a holistic approach to children's rights and understanding the rights of children pertaining to environmental rights and other rights. I mean, a mention has been made about Section 20, best interest of the child in South Africa. It's in Section 28.2 of our Constitution, but also the other rights that are related, particularly general principles under the CRC. Certainly, those are very, very important and are, cuts across and apply across all areas pertaining to the rights of children. Equally, the issue pertaining to participation, which I think when I was reading the general comment, once it was finalized, one of the things that struck me, and it links with what just the speaker before me was saying, Freya, is the strength in relation to child participation and advancing the voice of the child. That is something that is very crucial, but we know that there are challenges in relation to practically how do we do that, particularly when it comes to administrative processes before we even get to litigation. Yes, I agree with Professor Daly that we'll need trained lawyers who know how to really represent children in a way that's child rights compliant, in a way that's protective to children. But a lot of things happen before litigation. A lot of processes that government undertake, whether it's legislative, whether it's granting licenses for mining or all sorts of things, happen in spaces where children are not generally welcome. And even us as child rights organizations sometimes are not that welcome. And I've been reflecting a lot about what we can now, or what we now need to do to strengthen that. So just to give you an example, we tried when the call was out for comments on general comment, we collaborated with schools in 2 different provinces of South Africa, and we assisted children to actually make submissions to general comment as a way already. Locally, though, domestically, in relation to the processes of new legislation being written and the parliamentary processes, the spaces are very child unfriendly, let me put it that way. And currently there's a process in relation to the climate justice, the climate bill. When submissions were called for and we made submissions, we raised the point as the Center for Child Law that we're concerned that nothing in there really touches on how we're going to have a space for children to participate in the decision-making process, but also how there isn't really a focus on their rights in the proposed bill. So already there you can see that when laws are now written, the idea of, oh, now we're going to comply with what we expected for internationally and have a climate bill. However, we're leaving children behind, whatever, they must just be protected as everybody else. So those are the things that realistically on the ground, and before we get to filing our complaints to the CRC committee and all the regional bodies, we're going to have to grapple with on domestic level. And as I said, I've been reflecting a bit about how we're going to bring children to the fore. So to give you an example, there's a pending case that we loosely call deadly air that had to do with the fact that we have quite polluted air in one of the provinces in the country where there's a lot of coal mining. And the air quality is poor, and government has actually adopted the laws to say that they will put in a plan to reduce the pollution and actually address the issue of the air quality. What happened is that when that case, it's going on appeal. When that case was before the High Court, the applicants made a case that they're concerned about how the state is not taking action in 9 years, and how there is clearly an impact on children, on women, and persons with disabilities in particular. And when you read that case, you realize that the state actually had done impact assessments, and that clearly indicated the negative impact on the groups I mentioned, but had not been fair with the court and with the applicants in that case upfront to say, we have this. And later, when they were asked to give the record, that's when it came out that they had also done, they had done what's required in terms of the law, but had not disclosed that because obviously it's not in their favor. And there lies the issue of how do we in that space then take up the arguments in relation to the protection of children's rights, but also get the state to be honest. And that is really something that worries me, because the state has a lot of power, and if they're not honest and open in relation to taking these issues seriously and providing the reports, like in this case where they ended up in front of the court, it is really a concern. The judgment is a very nice judgment, very promising judgment, where the court interpreted the rights to a clean environment, and also then said that the state must now come up with requisite regulations. As I said, the state is appealing the judgment for certain reasons, and the Supreme Court will have to deal with that. But what also is linked with that case that I want us to reflect on as well, for purposes of not only litigation, as we do also advocacy in relation to the processes that government undertake, is that we will need to do our own research to counter states, where states sometimes might end up even not really being totally honest with the courts. And I realize that, again, this treaty is reminding us that you don't just wait for litigation. We need to be there in all the spaces. And I think it was already mentioned where the issues of climate justice and environmental issues are coming up in relation to children. And already there, we have the ammunition to counter where government is not complying, but also where they're not holding business accountable. We also know that this is an area where business has a lot of money and a lot of investment. It's not an easy space to litigate, even when you take on this. You might actually have a better chance when you take on the state, but the big businesses have a lot to lose to some extent, and they always will be very aggressive in their litigation. And therefore, we shouldn't just be focusing on how we're going to use the beautiful general comment wording and interpretation, but link that with proper research on those aspects, on the issues of impact on children, as well as kind of long-term and short-term, and why whatever the state or the businesses are proposing violates children's rights. And I do think the general comment, particularly the general measures of implementation section, do give us quite a bit to work with. Then there is also another case that's pending before the court, which is we call it Council Coal. South Africa has a nice way of coining the names of the cases because the parties have very long names. The Council Coal is a case where government, there's been an approval of a coal-fired power plant to bring 1,500 megawatts of power, but using obviously coal mining. And there the challenge is mounted against the approval for such, and the applicants in the case asking the court to review the decision. And when in the process there was an interlocutory application by the applicants when they were not happy with the record provided by the state as to how they got to their decision of granting this and whether they've done impact assessments properly, which again, general measures clearly highlight, how that is very important. Eventually then the High Court granted a court order where they, one of the prayers that the applicants asked for was that the state must clearly indicate if there was any efforts to ensure that children and young people were heard and that their interests were considered in allowing, the decision, granting the decision. Very nice, beautiful, short judgments, obviously enhancing and actually clearly saying how we should protect children's rights. But again, as a person who works on children's rights, I'm reflecting about are we doing that? How are we supposed to be doing that? Not just government, because for those children to be heard, they're supposed to be empowered. And government, you know, most governments would not go out of their way to do that. And again, it's a point for us to now reflect on this. As I said earlier, the General Comment is very clear in recognizing children's agency. It was already said, but that we know comes with a lot of work of not doing tokenism in relation to children, but really investing in educative approaches that are long-term, that also then will enable them to be the people who sometimes come to you and say, you know what, we think we're being failed because there's not this and this in our area in relation to our environment, and let's do a case. Because we also want children to start, you know, in some of our countries, we haven't really had children directly themselves rise up from the bottom and want to litigate. So that children can only do, you know, as Freya was saying, if they have the information that's accurate, and also we work with them in terms of long term and not do just a tick box that is done particularly by some people in relation to children, and equally so by the state, because we also know that the state, if they have now a court order like this, or if now the General Comment, we say to them, well, the General Comment says that we're supposed to have considered how this impacts children. Have you spoken to children? They would target maybe the children that are in urban areas, leave out the most affected children in rural areas. All those things come into play. And I think to really practicalize what the General Comment says for purposes of really being able to advocate for the protection of children's environmental rights, we have a lot of work that we need to do in taking these obligations up. So as I said, I mean, I was really focusing, really trying to link the general measures of implementation with what is currently happening in my small space of South Africa. I think we're just starting in relation to really this issue of centering children and bringing children's rights in this space. The two cases I mentioned are both pending, and our center will be intervening as amicus curiae in the case. And I'm really, really, truly excited about the General Comment, because it's giving us quite a bit to work with as an interpretive tool. And I think Professor Skelton mentioned that in some countries, the General Comment ends up carrying so much weight. And South Africa, up to now, we've been very fortunate to have very receptive courts when we make arguments relying on the treaty itself and linking it with the General Comments and our constitution, that you do end up with very progressive outcomes for children in relation to the interpretation and the protection of their rights and the protection of their rights practically. So certainly there is a lot that we need to do. And then maybe lastly, I should mention that also reflecting on the section on remedies is a very crucial provision and section in the treaty. And again, mentioning the fact that before we get to litigation, we're going to have to do quite a lot to use this in the space of administrative processes, but also taking children with us in that space and making submissions and influencing that space where possible before you get to litigation. And I say that because, you know, so unfortunately, in most instances, by the time we get to litigation, the damage has been done, and we're trying to play catch up in relation to these issues. So for instance, the new laws, particularly in South Africa, we have new laws and policies that are being worked on in relation to this issue. And we will definitely be investing a lot more time and effort in making sure that we engage with children in relation to the General Comment and what it entails, so that they are empowered to be able to make submissions in relation to the provisions of certain laws and policies. And obviously, as I said, where all else fails, this is an important tool for purposes of litigation. Yes, I think that's all I have time for. Thank you so much for the opportunity.
Thank you so much for this fascinating presentation. I am next in line, so I will quickly share my slides with you. Bear with me, please. Can I quickly check that you all can see that?
Yes, we can.
Thank you very much. So hello, everybody. It's a real privilege, and I'm delighted to join this great panel. I am Asteropi Chatzinikola, and I'm doing my doctoral work on child participation in climate change litigation at Cardiff School of Law and Politics and University of Bristol on an AHRC grant. Today, very unlike of me, I want to be talking about child participation, which was already brilliantly covered by Freya. But what I would like to discuss with you as a point of interest and further research is how the new General Comment number 26 could inform the role of lawyers in youth-focused climate litigation, and what are some of the key issues that we could see jumping up and jumping out of the General Comment that could inform our practice as legal practitioners and legal scholars. So very quickly, before I begin, I should thank a number of individuals and organizations that support my research and have supported my research in the past, but mostly to children, youth, and young leaders who have inspired this research, and they do inspire all my research activities to this day. Also to the Sabin Center team, Kemi and Tiffany, who have helped us to put together this panel with all the logistics, and also to Maria Antonia and her really inspirational work at the Sabin Center and the National Network for Rapporteurs, which really allows us to come together and collaborate and discuss significant issues such as this. So without any further delay, I want to discuss a little bit on the context of climate litigation. And I won't be spending a lot of time in this because Professor Berger already and Maria Antonia have mentioned about the trends of climate litigation and why it matters, what are the indirect effects of it. But what I would like to emphasize and to highlight is how disruptive the territory of climate litigation is and how uncertain it really is. And climate change has been described as legally disruptive by Fisher and other scholars. And this is because of its very characteristics as a natural phenomenon. So climate change has a transboundary cross-jurisdictional effect. And because of that, it really pushes us to reevaluate our tools, our norms, our legal frameworks, and it challenges traditional understandings of doctrines, including standing, sovereignty. And so climate litigation is really legally disruptive in the way that it fundamentally asks us to reevaluate if existing tools and norms are adequate to address the issues and the novel legal questions that are arising in so many legal cases that we've seen before national, international, and regional courts. So the climate litigation is legally disruptive, and that means that creates challenges for children to access and realize their rights. But children had already obstacles to access justice, to have effective participation, to really have access to an effective remedy. And so what it does, climate litigation, is only adds to this challenging territory even more. At the same time, we have some disruptive elements from within the body of youth-focused climate litigation. And Aoife has already talked about that, and many other scholars, that we don't have enough children's rights arguments in children's rights cases. So children may be the face of the case, but then sometimes, most of the times actually, their experiences in the here and now do not take a lot of center stage. At the same time, we have challenges with regards to new interests and how to represent them, such as of future generations, aspects that are discussed in literature by many scholars, including Aoife and the other Aoife, Professor Nolan. So I think we have a lot of issues that are arising in climate litigation. And at the same time, we have to pause and ask, we have challenges in legal frameworks, we have challenges in norms, but I think we need to highlight more how challenging this is for evolving and developing the practice and the procedures that are used when legal professionals work with children. So we could take a step back and actually say, okay, these are a number of questions, let's start answering them very slowly and gradually, but actually we don't have the time. Because then this is because we are very much pressurized by the continuously increasing numbers of cases. And I have presented this map before, but I think it's very important to strike and to emphasize how much the youth-focused climate litigation body has grown since Minors of Ozah in 1993. So in absolute numbers, we've seen many cases, most of the cases being filed in the United States, which is very interesting because, as many of you stressed out, we don't have actually the convention in the United States. So it is interesting to see how they construct the arguments. Then we have many cases in Canada and Germany, all top emitting countries. Then we have a thicker trend coming from South America, Central America. We have a few cases in Europe and in some regions for the very first time, such as in South Korea. So all these cases, and I should stress these are in national courts, actually tell us that legal professionals are working with children to bring cases in different contexts based on a different legal basis and to address their rights to climate justice and their rights to health, participation and development, and all the rights under the convention that are very much affected and disproportionately so by climate change. But what I think is very important when it comes to the general comment is not only that it provides a very useful tool of interpretation and authoritative guidance to see how the different rights of children interact with each other, but it provides a very useful document for lawyers, not only to construct arguments, which is very much needed. And as Professor Skelton mentioned, we really need lawyers to build their arguments within the framework and mentioning general comment. I think it provides a fantastic opportunity to reflect on our practice as legal professionals and as scholars, and to see how we can develop it further so it can address effectively the rights of children and how we use our processes to actually realize children's rights during this. And there has been research actually by Professor Skelton and Professor Nolan, and also by our other panelists, Karabo, Ozah, on how the convention should be used not only as a goal, not only as an aim, but as an inward lens for us to have all our practices and norms and the way that we work with children just permeated by children's rights, to make sure that we have children's rights compliant practices. So that's why I think that further research should really focus on how we educate lawyers, as Aoife mentioned, how we prepare them for this challenging territory. And I think that we should really place the discussion within the framework of general comment, and in the particular context of youth-focused climate litigation, not only strategic litigation, but the particular challenges that are posed by climate change. I will briefly mention some of the parts that really sparked my interest in the general comment, and I think that they are worthy of further research based on the discussion and the points that I've already highlighted. The first is that the general comment highlights that the process of realizing children's rights is as important as the result. And the committee actually led this by example, did not stay only on this important statement as words, because it really placed the views of children at the center of the drafting, of the consultation, even at the conception of the general comment. So I think this statement is very important, not only because it shows that our processes must be children's rights consistent and children's rights respectful, but also because I think it highlights how intrinsic is the value of children's rights. So, for example, participation, it's a very useful avenue for children to realize their rights and to go to the courts based on Article 12, but it also has an intrinsic value and it has many benefits for children. So I think that lawyers need to reflect on this and to remind themselves that when children participate in these cases, it may be for them to bring a very practical impact and to stop emitting countries from violating their rights, but also their participation has value in itself. Another aspect that I would like to highlight based on the general comment is the inclusivity of child participation. I was absolutely delighted when I saw the committee building on previous comments that participation is not only based on oral participation and language. So it mentions art, it mentions drawing, and I think it's very important to stress the inclusivity of participation and to explore it further, because not many children actually have the same language skills, not many children are at the same state of learning or evolving capabilities. And so I think that it really should be the basis for assessing and realizing child participation in this context. Another issue I would like to highlight is that the general comment notes that children's best interest should be determined with children's participation. And I know that best interests sometimes are willfully misinterpreted by states, and this was highlighted by Professor Skelton in the annual lecture at Doughty Street Chambers, which I had the privilege to attend. So I think that the best interest principle is both useful and malleable, so it should be carefully used and interpreted. But when it comes to determining children's best interest with children, I think that this is a game changer. So I think if participation is meaningful and effective, then children can actually express themselves through various forms and say which are the best interests for me. At the same time, I think that lawyers have a very important role to play when it comes to help states implement their recommendations of General Comment 26 and all the obligations that are stated within. And this has to do with two paragraphs that really sparked my interest. The first is that states should provide access to justice pathways for children, including complaint mechanisms that are child-friendly, gender-responsive, and disability-inclusive. So when I read that, I thought, well, legal professionals that are so extensively work with children to bring cases, challenging cases in this novel territory, they are the first observers of how children participate, how children can be included more effectively, and what could be better for them in order for their disability to be facilitated, for their participation to be really realized. So I think that lawyers should be key informants, if you like, and advisors to states on how states should make child-friendly mechanism, child-friendly access to justice systems and child-friendly complaints mechanism, etc. The second point is in regards to how effective is children's legal representation. And I think this is a key opportunity for legal professionals for reflection. And I think that when it comes to effective legal representation, two things should be highlighted. First, sometimes representation is equated with children's participation, and I think that this should be distinguished because I'm not too sure, and I have expressed my skepticism before. I'm not too sure that me as an adult could really effectively represent children's interests. Of course, I should facilitate them, and this is my obligation, but I think that direct participation of children and facilitating this should be the default position. At the same time, the second point when it comes to effective legal representation has to do with how effectively children have participated behind the closed doors with legal professionals. So when legal professionals take the time to actually understand what children they say through any form that they have decided to use to express themselves, I think that this is the starting point for effective legal representation. Of course, I mentioned before, there has been groundbreaking research on that by many of our panelists when they discuss how we can do child rights consistent practices, and there have been principles that they have advised on how to advance children's rights consistent practices, but I think further reflection should be done with that, with references particularly to the general comment, situated particularly in the context of youth-focused climate mitigation to address the very specific and unique challenges that I addressed earlier. So some very brief concluding remarks. Climate change is a legally disruptive phenomenon. I think it's vital for us as legal scholars and professionals and practitioners to keep reminding ourselves that this is an opportunity for development, for evolving practice, and also for innovation. And so I think that it is crucial to remind ourselves that anything is possible and to place children's views at the center of that. At the same time, child-focused climate litigation poses additional challenges to children's rights, so we shouldn't forget amid this chaotic climate change litigation territory that children had already challenges and obstacles to access justice. So we should consider that on top. Last, children's rights arguments should be more highlighted in children's rights cases, and general comment, I think, can act as a very good generator of children's rights arguments. Last, as I mentioned, I think general comment is a fantastic opportunity for legal professionals to reshape and reflect on their practice. And I think that the things that they need to pay attention to is the diversity of participation, building on the committee's previous general comments and observations, evaluate their own adult representation and how effective is this, and start seeing litigation more as a collaborative form between children and lawyers and not as an imbalance of power. So I very much look forward to your thoughts and to the questions, and please do not hesitate to contact me if you have any questions after the webinar. Thank you very much for your attention.
Thanks very much, Asteropi. It's I'm trying to start my video again, if the host can allow me. Thank you. So we have a couple of questions in the chat. We don't have much time left, but thanks very much for everyone's attention. Chris McConaughey, hello Chris, has asked a question about child rights impact assessments in the chat. He says, what is the scope What's the difference between a program and project? So I've just quickly looked at paragraph 75, which says that all proposed environment-related legislation, policies, projects, regulations, budgets, and decisions require vigorous child rights impact assessments. It does go on to say, of course, that if there's a broader impact assessment going on, this child rights impact assessment could be part of that. So, but whether it's a standalone or part of a broader impact assessment, there needs to be a specific dedicated attention to the impact on children's rights. So I hope that answers that question. Any other questions that people want to ask?
I think there are two other questions here that maybe I'll put them together. One is, how do we make sure that lawyers are trained on child rights in general comment 26 and how to represent children in litigation? I think some of these were touched upon, but maybe we can expand a little bit on it. And then there's another question, whether our work now moving forward is to relentlessly challenge every decision which does not conform to general comment 26 until business and government understand their duties to children. So maybe we can go around and everyone can share a few words about it, about those two questions.
Well, why don't you kick off, Antonia?
Well, I think part of the training is like doing webinars and understanding, like, studies like what we are doing. Obviously the committee has seemed very committed, to use that word, to really sharing it widely and making sure that Freya shared the child rights, the child version of the general comment as well, and all of that really helps in making that translation. But then I think the second question, I think part of it is yes, I think we need to make sure that this is spread widely and that courts are applying it and so forth. Yeah, but I'm sure the others will have more things to share about it.
Any other speakers, panelists, please jump in.
Thanks so much, Anna and Maria Antonia. It just occurs to me, of course, Professor Aoife Nolan in Nottingham and yourself, Anne, and Karabo have been working so hard on strategic litigation from a children's rights standpoint with the ACRISIL project. So you guys have already been doing so much work to bring children's rights to practitioners. And my project, Youth Climate Justice, with the European Research Council, will, likewise be doing some of that, be working with and conversing with lawyers that are specifically working on environmental and climate justice cases with children and embedding children's rights in that work too. So I think there's, a lot of exciting work to be done, and practitioners, so many of them are so eager to do that work. And I think those of us, like myself, who have expertise in children's rights, who are academics and so on, can work together with legal teams. Like, for example, I got together with, the 6 Portuguese youth, their legal representatives in Doughty, Agostinho in the European Court of Human Rights, and went through with them some of my children's rights knowledge to bring to the case, and they found that very useful. And of course, it's such an enriching exercise for me as an academic as well, that my knowledge is able to kind of come to life a little bit. So I guess there's loads of opportunities for us to work together to bring children's rights to these cases.
Maybe just spinning off, Aoife, from what you've just said, some of the work that we did in the Advancing Child Rights Strategic Litigation Project was, looking, of course, very often the convention and general comments are used to show the state what constraints or at least what their obligations are and what rights violations have occurred and so on. But we as practitioners less often turn that towards ourselves. So when we are litigating, we should also be checking, are we fulfilling the rights issues that are there in the convention and in the general comment as well. So if children are to be agents of change, then we do need to think about how we engage with them, and getting the balance right between, encouraging them to express themselves, and at the same time protecting them from the potential harms that can occur in this kind of high stakes litigation, is something that we all need to think about as well. And I think we've still got quite a long way to go on practice in relation to this.
Can I maybe come in on the second question, because I think Anne and Aoife have covered the first one, but on the issue of, are we going to relentlessly be pursuing every decision that does not consider children's rights in relation to this issue? I certainly think we have to, but as I said when I was doing my short kind of presentation, the different spaces matter. So it's important that, like now, if in South Africa we have a climate bill, we've made submissions, we've told them what's wrong with it, why it's not sufficiently covering the interests of children and the impact on children, so that by the time you get to a point where the bill is now adopted and you have to litigate, you also have a track record of how government is failing. So I would say, yes, obviously we do this strategically, but in all spaces when there's call for comments on new laws, new policies, we have to be in that space and use that space, so that if that fails, then if you end up going to the court, you've already now have record of what you've tried to show government and or business, their failures, and how now you have to resort to this other mechanism. That is very important. And I think another thing in relation to litigation as well, domestically, it is like there's been quite a lot of successes, but we must also highlight the fact that there's some cases where people have not come right because courts are reluctant and conservative. And at some courts, for instance, in South Africa, if you have clear record of the failures to consider things and a continuing one, you have a better chance of succeeding with your litigation. So we must not also have this idea that litigation is going to always be successful, always solve the problems. So we definitely have to be in all the sports, but strategically so, and build up so that when you do have to litigate, you have backup. And as I mentioned, also we have to also invest in our research, and I'm glad that Professor Daly is now doing that research that she's doing. We need to have research. Government is going to come, business is going to come with their research that, as I say, sometimes is not reflecting things properly. So we need to also do that, because courts also want evidence. They can't come and just say this violates article so-and-so of the CRC and general comment so-and-so. I need to clearly have ammunition, and on this particular issues that are very contested, the evidence is also very crucial. Thank you.
I think you're right. And Karabo, of course, although in this seminar, we happen to be focusing on the use of the general comment in strategic litigation. But I mean, there are so many other ways in which it can be used, which I think some of the speakers have also touched on. But if you were making presentations to a bill in Parliament, then you would equally be able to look at the text and try and convince parliamentarians that this should guide them in the way, in the decisions that they make in lawmaking too.
Right. One of the other question that I had was if maybe we could talk a little bit about how the general comment could influence the ICJ advisory opinion on climate change and potentially the Inter-American Court one as well. So I don't know. Well,
definitely. I mean, the filing of documents for the ICJ case is already, the date had gone past, but fortunately there's now an extension on the date. So as I mentioned, the committee is urgently looking in to see whether we can find a way to get it put before the International Court of Justice, so that it's one of the filed documents that they can have reference to. If we need any support in that, we will reach out to partners like yourselves, because obviously not everybody can just put documents before the ICJ. But I think that is a great opportunity, and similarly we're looking at the how do we go about the process for the Inter-American Court of Human Rights. So if you also I think we can partner on this as well and see, what opportunities there are. If you know of opportunities, please reach out and let us know. I'd be interested to hear, does anybody know, was it used or argued in the Portuguese children's case? Were any of you at court? Maybe it was.
Yeah, that's a good question.
When they filed their paper, when the original papers were filed, the general comment wasn't available.
Yeah.
But the argument was just last week, I think, or the week before. And so by then it was available. So I'm not sure whether it was included into the oral arguments, perhaps.
Yeah. I don't know, Aoife, do you have any sense or any comments on the advisory opinions too?
I didn't notice that it was included in the submissions, but I couldn't be sure. But that's a really good question. I'm going to have a little check of that.
I think it has the potential to be very informative in both. The Inter-American Court is really open to, like all sorts of norms that can have application, even on binding ones, and it's usually perceived as a very progressive court, so I think it can have a significant impact. And children is also like a very specific part of the question that was posed to the Inter-American Court, and for the ICJ, I think it relates so much to children, even though I think they do have actually children and future generations included in the question as well. So, it would be interesting to see how that applies. And I'll keep it in my notes too, because we did a summary of the ITLO submissions, used our network of rapporteurs to do that. And we published that last week. And they went through all of the submissions. We had about 20 volunteers doing that. And I'll keep a note out for them to, once we do that for the Inter-American Court and the ICJ, for them to check if the general comment is being mentioned as well throughout.
It'll almost be coming full circle, because the Inter-American previous advisory opinion actually heavily influenced the committee's decision in the Saki case. So it'll be interesting to see then how they feed some of the stuff from the general comment back in.
I have a question for Aoife based on her very exciting article. So you mentioned that children's rights arguments, of course, should take more center stage, and at the same time that we should place children in the intergenerational spectrum. We should not overemphasize the distinct categories of children, future generations, because we lose out this intergenerational aspect. And also in this context, you note that children's rights arguments should be invoked along with future generations arguments. So I was wondering in this, how you think general comment could strengthen this combination, this collaboration of arguments going forward.
Yeah, I mean, that's an excellent reflection. I think I think that there is, there's a little bit of tension there. The Maastricht Declaration on the Rights of Future Generations, it was decided that children were not going to be, it was very much going to be people who have yet to be born, was going to be the definition there of future generations. And it's difficult to say with authority or to try to define future generations, because of the fact that it's in so many national constitutions and understood in so many different ways. So as for the intersection with children who are here now, I think it would take a lot of reflection to actually define that. But what is clear is that children's rights arguments are being eclipsed. I think it's clear. Children and the children's rights framework is being eclipsed by this very, very useful concept and legal concept of future generations, which is so useful for so many purposes. But I think the general comment is just such a useful tool to bring back some of that attention and to actually center children here now, having experiences now, which is the most important thing for them, as part of the case, and for lawyers to reflect on how it might be possible for them to be more bold about engaging the CRC in the work that they're doing. And we have this really thorough, really exciting general comment that I think just gives more tools to do that. So it's a great question. We don't want to sideline either future generations or children, or to, you know, act like there's too much competition there. But at the same time, children are the faces of these cases, they're the names of these cases, and their rights, I think, need to be more center stage, and the general comment can help to do that.
Thank you so
May I
much.
just say something? I'm just reflecting on that and I'm thinking out loud, and Anne can tell me whether she thinks I'm off the mark. I'm just thinking about one of the dangers of going too much with future generations argument is that in countries where there is a progressive realization provisions of rights, government might use that to delay. So sometimes if you're arguing that for the future generations, and they say, well, future generations gives us a little bit more time, right, to do 1, 2, 3, 4. And I think I mentioned some of the one of the judgments I mentioned earlier, the Daly, the court interpreted that our right in our constitution to an environment that's not harmful to your health, it's an immediately realizable right? Because people are here, children are here today, and there were reports that showed the harm now. So I would say that, I mean, as I say, we all have to start domestically using the general comment before we get anywhere else, whether it's, you know, the Inter-American, the European, or the CRC committee. It is very important to also be mindful of the context in which you're operating and how, you know, the argument you're making on that and relying too much on intergenerational rights might do harm to other arguments. So that's something that I would say from a strategic litigation reflection kind of view, you know, thinking out loud. I hope I make sense. I would be mindful of that, and I'll look at it in closer detail.
Well, I think, Karabo, in South African constitution, future generations is actually framed more as an obligation. It's everyone's obligation to ensure that the environment is preserved for future generations. And it just so happens, I often say, that it's children that's standing up to act on that obligation very, you know, noticeably. I tend to think about this as well as a difference between proximate and proxy. So the Maastricht principles have said that children are proximate to the future generations. In other words, they're going to live longer, they have more of a kind of connection with future generations. But that doesn't mean that they should serve as a proxy for future generations, although they quite often want to, or that is something that they say. So you'll see in the general comment, this is actually quite weak. And the reason was that, because there was disagreement within the committee about how much to go in detail because of the very debates that we're having right now. And so in the end, what we focused on is what the children themselves say about this. They frequently refer to themselves as future generations, but that also could be an echo chamber in which, you know, people often, adults refer to children as the future and all of that kind of, you know, I always think we're about to break into song, you know, we are the world, we are the future, etc. But I think what we should do is we really need to keep our feet on the ground on this one. Let's be careful. Let's be cautious. Let's focus on children's rights as much as we can, we who are children's rights lawyers. And let's remember that children may be proximate, but are not necessarily proxies. That's what I think.
Excellent. I have another question that's also maybe a little bit out there, but I've been starting to do some work with 2 other colleagues on gender as part of climate litigation, and how women have actually, you know, there's some talk about women bringing some of these cases, but the gender arguments really not being put forward like at all really in climate litigation cases. And one of the things that we think about a lot is how you know, women are also not really part of the children conversation, like often, you know, obviously it is implicitly but not explicitly. And obviously, you know, women with you know, breastfeeding and like carrying children and so forth, it's essential that climate change law also protects them as with this interrelation to children, right? I'm not articulating this properly, but I think you can get my point. So I was wondering if you had any thoughts on that, and you know, how we can sort of make that connection a little stronger moving forward, and have that show up in climate litigation as well moving forward.
So maybe there you're talking about intergenerational effects, right? So for example, if a woman is living in an environment that is harmful to her health, and then she she's carrying a child, that child can be affected as well. The only danger that I see looming huge in that is the risk of implying that the unborn child has rights, which is something that we at the Committee on the Rights of the Child are quite cautious not to do. So all of these arguments have some risks attached to them. Of course, the Maastricht principles also carefully, exclude that. They do put that, they make it clear that they don't intend to confer any suggestion that there's rights on unborn children. But it's a dangerous path to walk. But I think nevertheless, it is important to acknowledge that there could be intergenerational effects of harms to the environment that would be very relevant to litigate about. But I just hope that the people who litigate about it are careful about these characterizations and not just throw everything in without thinking about what the impacts of that will be on the rights framing.
Yeah,
this is something, oh, sorry.
Yeah, go ahead.
Oh, this is something I've been thinking about and writing about for the past 2 years, and it's actually culminating in a book chapter that 3 of us here are all contributing to a book towards. And some of the many things I've seen is that sometimes if we group women and children together, we have to be careful not to infantilize women by including them both within the same section. I've also seen that from the other end of the spectrum, I've seen an article talking about the UN CRC and how it's the most feminist of the conventions because it's the first to use both he and she. And then there's even the case, I don't know if you've heard of it, I believe it was a Swiss case of an elderly group of women who were being impacted by climate change, and they were successful. So not intergenerational, but a specific group of women talking about the gendered and age impacts of climate change, and they were successful, and I find that particularly interesting. But including women and children within the same subject for litigation, I think it's going to happen, and I'd be surprised if it wouldn't happen because they are so entangled in so many places. Children are the most impacted and women are the most impacted, especially in the Southern Hemisphere, and the interrelation between the two is just inseparable. But hopefully we see it without this infantilization, without including women and children as this one homogenous entity. And I would just be fascinated to see how this moves forward. But yeah, I'm trying to think how to summarize my thoughts. I just have so many at this one point because I'm finishing up this book chapter. But yeah, I do think it is definitely going to happen. How it does, how it progresses, and hopefully with the general comment, with both the vocal voices of women and children moving forward, will be great. And I look forward to seeing what happens next.
Maria Antonia, when you refer to breastfeeding, there is perhaps a useful illustration in literature which describes women and children that are breastfed babies as a dyad, so an inseparable entity. It's a unified thing. So I think this could be particularly useful in illustrating in court how children that are relying on their mothers for their food should be considered as one person, which of course it has its implications and it shouldn't be used very, very lightly, but in terms of giving an illustration of how a woman who breastfeeds and her baby have rights that are interrelated, I think a dyad is a good illustration, which I found useful in case you find it interesting.
I'd be a little bit cautious, but because I don't like the kind of fusing that I hear in there, but interesting work by Jennifer Nadelsky when talking about the interests of the unborn child vis-a-vis the mother in reproductive health. She talks about not one, but not two. Not one, but not two. So a kind of connectedness, she calls it the relational theory. So there is a relationship between the mother and the child, but that doesn't make them one person, but they're not quite two people if the child's unborn. But once the child is born, then they are definitely two people. So if we're talking about pregnant women, that's one thing. If we're talking about breastfeeding women, that's 2 people. So these are all the huge risks, really important conversations for us to have. And I think if people are going to be litigating in the space, that they need to think carefully about some of these things.
I would also look to, oh, sorry, Maria again. I would also look to the enhanced Lima work program on gender from the Council of Parties and the CEDAW General Recommendation 37. They really talk about women and climate change, and there's sections both including children and how they interrelate. And I have different opinions on both, but I will leave that to another talk.
Yeah, it sounds like we need another webinar to talk about this. But this has been really useful. And, to be clear, the article will be 90% focused on women, and, potentially gender more broadly. But I think there's some connections that are worth mentioning. But I think, Ken, you're very right that it needs to be cautiously argued. Any other questions? Yeah, Asteropi.
Just to quickly add to that, so to avoid any confusion, not to consider mother and child as one person when it comes to everything. Perhaps I wasn't clear, and apologies for that. To consider it as a dyad when it comes to the infant's feeding, so that it's so dependent that they cannot be really considered that they can do it alone because they are expected to be breastfed. So just a very, very small footnote to avoid any confusion.
Well, considering we don't really have a clear facilitation rule, I think we've done quite well. But I feel our participants, they've really been stayers. There are still 17 participants, which is fantastic. Or no, that's including us as panelists. So we're probably reaching the point where if we become the same number of attendees as panelists, then we ought to call it a day. And we're probably getting towards that point now. So I don't know, do you want to, Maria, Antonia, would you like to sort of sum up and say goodbye to us all?
Yeah, absolutely. Really to thank our wonderful panelists. It was a really incredible discussion, and we had a really engaged audience as well, even though we didn't have a lot of people joining. So that's always excellent. And yeah, we're really looking forward to see how this continues moving forward. This was part of the Sabin Center's network of rapporteurs on climate change litigation, and some of the panelists here are part of our network, and it's really, I always really like to thank them for their efforts to making the database more comprehensive and to making these wonderful events and blog posts and information available so that we can share with a wider audience. Yeah, so thank you everyone for joining, and we'll see each other soon, I hope.
Thanks everyone. Bye.
Thank you. Bye.
Right. Thanks so much.